Thank you, Chairman Comer, Ranking Member Raskin, distinguished members of the committee. I'm grateful for the opportunity to testify today. And in my opening statement, I would like to make 4 main points. The first has to do with the administrative agencies themselves. Any conversation like this about administrative agencies and regulations tends to involve a lot of numbers, a lot of very specific rules, often a lot of acronyms. But I would like to focus on 2 main themes or trends of recent years. The first has to do with the regulatory initiatives and ambitions of a number of agencies. Agencies now more than ever are the center of gravity in government and policymaking, and the center of gravity in terms of the political energy around policymaking. And because of that, or with that, a number of agencies are showing great ambition in pursuing transformative rulemaking initiatives. Transformative not just in terms of the industries or the public interest, but also transformative in terms of the agencies themselves. A number of longstanding agencies are pursuing ambitious new regulatory programs that would fundamentally change the mission of the agency. At the same time, the second trend I want to focus on is the issue of regulatory uncertainty. A number of agencies are achieving their policy aims right now, not just by imposing new regulations, but by taking down a lot of guidance or other rules or standards that allowed for regulatory certainty to take hold. Agencies are leveraging uncertainty, and I think that's very, very worrisome in terms of the stability of the rule of law. My second point has to do with the Supreme Court. At the same time that this is happening in the administrative agencies, the Supreme Court has undertaken a number of decisions in recent years and decades to make administration more lawful and less unsteady. I think most prominent in recent years has been the major questions doctrine, but through which the Supreme Court has tried to read agency statutes, especially long-standing agency statutes, much more reasonably in terms of not just the Constitution's separation of powers, but also in terms of the experience of those agencies going back decades or more. The major questions doctrine, I think, is an important judicial tool for limiting agency adventures. But at the same time, the Roberts Court has issued a number of decisions that help to make administration steadier, more predictable, more transparent, and more analytically rigorous, and including not just cases involving the Biden administration or the Obama administration before it, but even the Trump administration. During the Trump administration, we saw a number of Supreme Court decisions that pushed back against agencies for not sufficiently explaining their regulatory decisions. So across the board, the Roberts Court for now nearly 2 decades has tried to make the administrative process more lawful and more steady. And I think that's important because of my third point. My third point is about the Constitution, and especially the Constitution's founding purposes. Of course, the Constitution was created to ensure checks and balances and to protect individual liberty. But another theme of the founding generation was the need for good administration, by which they meant steady, lawful, and energetic administration. And a number of the Roberts Court's decisions, I think, trend in that direction, at least in terms of the steadiness of administration. In my written testimony, I go on probably at too much length about the writings of the founders and explaining how they saw good, steady administration. But I think it's important not just for its own sake, but also as an important way to understand what the Roberts Court is doing. Alexander Hamilton said that the true test of a government is its tendency and aptitude to produce a good administration. And I think that's something we all need to keep in mind. And then my fourth and final point is about Congress. So much of what we're discussing today is just a downstream effect of the fact that over the course of decades or more than a century, Congress has delegated immense powers and immense discretion to administrative agencies. A lot of what Congress is doing in terms of procedural reform, what the Supreme Court is doing, is trying to dampen the effects of, or limit the effects of immense agency discretion. So the first thing Congress could do to help solve some of these problems would be to modernize and reform the underlying substantive legislation. But in addition to that, there's a lot that Congress can do, as I describe in my testimony, to improve the procedures that agencies use and also to improve the procedures for judicial review of agency action. And I'd say that as we enter a moment when the White House and OIRA are beginning to undertake changes of their own that I think will unsettle some things, I think now more than ever it's important for Congress to ensure greater stability in the administrative state. Thank you very much. I look forward to your questions.